Welcome. You are listening to the Louie Minor Show. I'm your host, Commissioner Louie Minor. Today is April 15th, 2023. We have a lot to discuss on this week's show, including the recently filed lawsuit. So let's get started. So the first thing that we'll talk about is the agenda for April 17th, Monday, 2023. First thing on the regular agenda is the invocation and the Pledge of Allegiance. Next item is the consent agenda. Consider the approval of the April 10th, 2023 Commissioners Court meeting, personnel budget amendments, claims payable, payroll, restitution, jury pay. Then we have consider authorizing the award of IFB 30-23, installed 2 inches hot mix asphalt overlay on Rose Lane intersection in Precinct 2 to the lowest responsible bidder, Texas Materials Group, Inc., at a cost not to exceed $34,096.70 for the Road and Bridge Department. Item E, consider authorizing the county judge to enter into a lease agreement with the City of Temple for use of Cora Anderson Building under the terms and conditions of the term sheet presented by the City of Temple. Item 4, proclamation proclaiming the month of April 23 National Donate Life Month in Bell County, Texas. Item 5, consider the appointment of a hearing examiner for a game room permit appeals relating to Bell County game room regulations. Item 6, consider authorizing the county judge to execute a change order request in the amount of $111,146 for the addition of a fire pump system on the jail loop expansion project. Item 7, consider authorizing the county judge to execute an assignment and assumption agreement relating to Panda Temple Power 2 LLC. Item 8, consider authorizing the county judge to execute a memorandum of understanding between Bell County, City of Belton, and WBW Single Development Group LLC relating to Three Creeks Phase 9. Number 9, consider amending rules of procedure, conduct, and decorum for the meetings of the Bell County Commissioners Court. Item 10, County Engineer, consider and approve a final plat of the Tanglewood, amending plat number 14, being a 1.39 acre, 2 lot, 1 block subdivision located within the City of Temple ETJ, Bell County Precinct 3. Then we have county judge and commissioner announcements. And that is everything for the Monday's agenda. On the workshop, let's go to Monday's workshop. First morning workshop beginning at 10 a.m. or immediately following the commissioners' meeting are reports and updates from county offices and departments, capital improvement projects, discuss the Bell County Historical Commission appointments. Then we will enter into a closed session, deliberation about deployment on specific implementations of security personnel or devices, and that is going to be brought by Judge Blackburn and Sheriff Lang. Then in the afternoon workshop, beginning at 1:30, discuss special districts to include Solano Ranch Municipal Utility District, Deer Creek Ranch Municipal Utility District, and Knob Creek Municipal Utility District. That'll be Judge Blackburn. Then we have discuss Bell County Indigent Cremation Policy and body donation. And then we will have the FY 2023 mid-year review, departmental hearings relating to updates and requests for budget amendments, and that'll be by the county auditor. And then they have county judge and commissioners may attend meeting and events where county elected officials may attend, and county business may be discussed but no action taken unless otherwise posted. This always gets updated every time we get invited to things, but I'll run through them real quick just for your sake. We have the Conference of Urban Counties. That'll be April 19th at 9 a.m. That'll be in Austin. Then we have also on April 19th at 9:30 K-Tempo meeting. April 22nd, Southwest Bell Fire Department barbecue fundraiser. Also on April 22nd at 10 a.m., we have the Bell County Auction, Wildfire Ranch Salado. April 26th, we have at 9 a.m., we have the Central Texas Public Transportation Summit. That'll be in Coppers Cove. April 27th, we'll have the Central Texas Council of Governments Executive Committee meeting. May 1st, we will have the Bell County Extension Education Association Rally Day. That'll be in Temple at Grace Presbyterian Church. May 4th, we will have preparation for the Bell County Employee Barbecue Luncheon and Service Awards for county elected officials and employees. Then we will have on May 5th, the Bell County Employee Barbecue Luncheon and Service Award at the Exposition Building at the Expo Center in Belton, Texas. And then on May 9th, we have the redesignation ceremony. Fort Hood will be officially redesignated to Fort Cavazos. That'll be at 3 Corps Headquarters, Fort Hood, Texas. Now, I will be there, without a doubt. That's an important moment in history. That is an important moment for our community. And as the only veteran on the Commissioner's Court, as the only commissioner that supports removing Confederate history and celebrating our federal government, our current way of governing our country the way it is now, I will be in attendance. I really hope that the other commissioners don't go. I mean, they show an affinity to the Confederacy, and I think it would be sad to see them there celebrating that redesignation. But anyways, we'll get off that soapbox and get on to, I guess, the main story for this week. I didn't do a show last week. We had a very brief Commissioner's Court meeting. There was not a lot of items on there for action. I think we only had 2 action items on there. One of them, the one that the paper reported on, was the Commissioner's Court approved a school resource officer for the Central Texas Christian School in Temple. I oppose that. I oppose that because I don't think that the county should be in the business of providing security. Now, many times, because our officers are underpaid, they have to seek outside work. So typically they will work security jobs at clubs, restaurants, churches, construction sites, you name it, weddings, anything like that. Uh, Officers will work security and get paid for it on their off time. On their off time. This is creating a position that Commissioner Snyder said would be paid for by the school, up to $87,000 a year. But I didn't buy it. There's going to be incidental costs associated with that position. They don't have to hire for that position. The sheriff's department said they had a qualified person to go right in there, but his position would have to be backfilled. So automatically, we're already having to fill a position, which costs the county money. So we have to pay for training, radios, anything like that. The county's going to be on the hook for. That's why I oppose that. The school, no one is forcing them to be in business. No one is forcing them to have security. But as a responsible business, they want to have security at their school, which is great. I commend them for that. They want to protect their students. They want to protect their business. So you need to pay for your own security. I asked Commissioner Snyder, why didn't he go to Temple? It's in Temple city limits. Why didn't he go to the city of Temple and ask for them to create an officer? Why did he come to the county? And he said because it would save them money. And by them, I mean the school, not the county. So, that's why I was opposed to it. And the first thing that they mentioned was, I don't want to protect kids. No, that's not the case. That's even silly to assert something like that. I have a grandson in school, in a private school. And if that's something they decided to do, great. I would support that. But, it's their responsibility. I do not care that they're already paying taxes. That's their responsibility as a landowner. But just because you're paying taxes does not mean that we should be spending tax dollars on private schools. There's a thing called separation of church and state, private and public. Those are different designations for a reason. And I'm going to be watching this like a hawk. And any penny that we spend on that position, that RSO position, I'm going to make sure that the county gets reimbursed from the school. $0 should be coming out of the taxpayer's wallet to pay for that position, whatever it is. So we'll move on to the next topic. This week, we had the long-awaited lawsuit from Bell County filed in district court. And let me pull this up. It is a clip from the local news.
Bell County Attorney Jim Nichols says that Proposition A is unconstitutional and inconsistent with the state law.
Passed on November 10th of last year, Proposition A contained a city ordinance decriminalizing possession of misdemeanor amounts of marijuana. Now, District Attorney Henry Garza and County Attorney Jim Nichols are challenging the City of Killeen, requesting an immediate temporary restraining order and removal of the ordinance in print forms from any and all publications.
Cities aren't free to just create a patchwork of what criminal laws they want to enforce and what criminal laws they don't want to enforce. That's something that has to be done statewide through the legislature.
The Proposition A lawsuit targets municipal ordinances affecting enforcement of state criminal law. It could also set the tone for cities like Harker Heights, which is about to vote for a second time on its version of Proposition A. Voters passed it, but the city council later struck it down.
They cannot conflict with existing state law.
In 2022, the Bell County Commissioners Court unanimously authorized the lawsuit, but newly elected Precinct 4 Commissioner Louie Minor wasn't in office and now opposes the lawsuit.
I think it's a big waste of time. To me, it's obvious where the city stands on this. Almost 70% of people voted for this to pass, so we expect the city to stand up for the citizens and push back on this.
Commissioner Minor also encourages Harker Heights residents to be aware of what their city officials are doing and make sure they support your beliefs. Nichols says Bell County and district officials want to undo Proposition A permanently.
Officials with Bell County are still waiting on a response from the City of Killeen. But in the meantime, you can always stay in the know by visiting our website at fox44news.com. Live in the newsroom, Renako G, Fox 44 News.
So there you have it. We now have an active lawsuit. Bell County. Well, let me read how it's styled in the lawsuit. The state of Texas and Bell County, Texas versus the city of Killeen, Texas. In the District Court, 146th Judicial District, Bell County, Texas. This was filed April 11th, 2023. Now, the 146th Judicial District judge is Jack Jones. I believe he is the senior judge on the court in Bell County, and he is also the administrative judge for the county, the judicial administrative judge for the county. So let's dig through this petition. It is 19 pages, and we'll see how we can, I'll give you the cause number. You can look it up. Go to Bell County District Clerk website, Odyssey, and search cause number 23 DCV 338257. So let's get to the parties. The state of Texas, as the plaintiff, is represented by her district attorney, Henry Garza, and her county attorney, Jim Nichols. Both elected officials exercise the jurisdiction of their office in and throughout Bell County, Texas. Both officials reside in Bell County, Texas. The defendant, the City of Killeen, as defendant, is a home-ruled municipal subdivision of the state of Texas located in Bell County and may be served through the mayor of Killeen, Debbie Nash King, located at 101 North College Street, Killeen, Texas. They talk about venue and standing. Let's go to the standing portion of it. Jurisdiction, let's see. They mentioned the Bell County Commissioners unanimously authorized the county attorney to seek the relief herein. County Commissioners have a general duty with respect of public safety and health of county residents, and the Commissioners Court undoubtedly has the right to cause suit to be instituted in the name of and for the benefit of the county. Both the state of Texas and Bell County have been harmed by defendants' actions, and this suit brings this honorable court to provide the judicial remedy sought by declaring the ordinance unconstitutional and enjoining the defendant from enforcing it. The venue is proper in Bell County, Texas, because defendant City of Killeen is located exclusively in Bell County, and its ordinance, which is the basis of the plaintiff's claims, causes the action has been enacted and given effect in Bell County. So, okay, I don't see how Bell County is harmed. What does harm mean? It means an adverse action. What adverse action has happened in Bell County other than our jails are not clogged up with low-level marijuana arrest? Our court system is not clogged up with low-level marijuana arrest. Maybe they're referring to all the money that they get from these arrests, these marijuana arrests. Maybe that's the harm to the county. They don't get to profit from minorities and low income and the sick and veterans that use marijuana here in Killeen. Maybe that's the harm. But let's read on. Facts of the case. Through the ballot initiative process, facts of the case. Through the ballot initiative process, the citizens of Killeen placed Proposition A on the November 8th, 2022 ballot. Proposition A contained a city ordinance which would eliminate enforcement of the marijuana laws by the Killeen Police Department. Proposition A passed on November 10. Proposition A passed. On November 10, the Killeen Police Chief directed his officers by special order to cease misdemeanor marijuana arrests. After certifying the election, thereby adopting the proposition, City of Killeen amended the ordinance on December 6 and codified and published the modified ordinance now in effect. Code of Ordinance, Chapter 22. Police, Article 5, Marijuana Enforcement attached. Hereto, as Exhibit 1, the referendum throughout this petition as the ordinance. The neighboring city of Harker Heights faced the same election initiative proposition on November 8th. However, after certification of the election results, which tactily adopted the proposition, Harker Heights City Council repealed it on November 22nd. On December 22nd, 2022, the Bell County Commissioners Court unanimously authorized the Bell County attorney to file suit against the City of Killeen. See Plaintiff Exhibit 2. Causes of action for declaratory relief and request for injunction, temporary and permanent. By this action, plaintiffs seek a declaration from the court that A, the City of Killeen ordinance to eliminate low-level marijuana enforcement codified in Article 5, Section 22-80 through 22-86 is inconsistent with state law and therefore invalid, void, and unenforceable. And this same ordinance suspends state law and is therefore invalid, void, and unconstitutional. Plaintiff's request for immediate temporary restraining order and injunction enjoining defendant City of Killeen and its agents, one and all, from enforcing Article 5, Chapter 22 of the Killeen Code of Ordinance. Let's see. Plaintiff requests that the city secretary immediately remove from the publication the ordinance in print form, including online municipal code database. Plaintiffs request that to any extent it may be in effect, the chief of police countermand his order that followed the election until superseded by the adoption ordinance. Finally, plaintiff requests a permanent injunction against the city and its agents from enforcing Article 5, Chapter 22, Killeen, Texas Code of Ordinance. Plaintiff requests a permanent injunction in concert with the above following trial. So that was a lot, but they're just saying it's illegal. The same things we heard throughout the process that we have to enforce it, but we know that's not the case. Officers and county attorneys, district attorneys, prosecutors exercise discretion every day, all day, every day. This is citizens exercising discretion through the city, directing its officers what they want the local police department that we pay taxes for, what we want them to concentrate on. But a judge is going to have to rule on it now. And I've said this multiple times. And all of this, I guarantee you, and I'll bet $100, I'll guarantee you, we can go and research the county attorney's records and the district attorney's records and see how many times they have done plea deals on marijuana, on driving while intoxicated, DWI, and I bet you there's going to be a lot. And that's just those two. If we expand it to everything that comes before them, let's see how many times they plea deal things down to get a conviction that they don't have to go to trial for to get that conviction rate. So by them doing that, are they soft on crime? Are they circumventing the state law, circumventing what the police department, what the officer arrested them for, charged them with? Maybe. Whenever I was a cop, I arrested someone and they fought with me, resisting arrest. And they pleaded that down to something lesser. Now, don't think I was not a mad police officer when that happened. So let's look at that stuff. County attorney, district attorney, because I assure you, you've done it. And the citizens need to know you've done that. You've done plea deals, plea bargains. So are you not following the state law? Okay. Legal analysis. Plaintiff believes that the City of Killeen Ordinance, Chapter 22, Article 5, is unconstitutional and inconsistent with numerous state laws that have supremacy over municipal ordinance. Killeen is a home rule city. Yes, we know that. As such, the city does not need any special grant from the state legislature, to enact various local laws. However, Article 11, Section 5A, the state constitution provides no ordinance passed under a city charter shall contain any provision inconsistent with the constitution of the state or the general laws enacted by the legislature. As the Supreme Court of Texas ruled in City of Laredo versus Laredo Merchants Association, the question is not whether the legislature can preempt a local regulation like an ordinance, but whether it has. Let's see. Then it says the Honorable Court needs to look no further than Texas Local Government Code to see the state has preempted Killeen's ordinance in its entirety. I don't see it. They have underlined the county, municipal or county police policy regarding enforcement of drug laws. The governing body of a municipality, the commissioner's court of a county, or a sheriff, municipal police department, municipal attorney, county attorney, district attorney, or criminal district attorney may not adopt a policy under which the entity will not fully enforce laws relating to drugs. A policy. An ordinance is not a policy. Just saying. You got to read these things verbatim for what they're worth. Plain text. A policy and an ordinance is not the same thing. So they give the definition of marijuana, the statute in the Health Safety Code, which is often referenced, possession of marijuana in this chapter. Let's see, person commits an offense if the person knowingly and intentionally possesses a usable quantity of marijuana. Under this offense, Section A is a Class B misdemeanor and a Class A misdemeanor for 4 ounces or less. They go on in their evidence. Ordinance negatively affects plaintiff's focus on Article 2.13, which defines the duties of police officers for the most obvious and glaring example. B4, the officer shall arrest offenders without warrant in every case where the officer is authorized by law, in order that they may be taken before the proper magistrate or court and be tried. And B1, in every case authorized by the provision of this code, the officer shall interfere without warrant to prevent and suppress crime. Plaintiff maintains that this article requires officers to seize contraband so that the person cannot continue to violate the laws. The Killeen Ordinance changes the nature of the CCP from mandatory to discretionary. Officers may seize the marijuana. Well, I hate to break it to you, county attorney and district attorney, but the chief of police stated whenever he did his 3-month report to the city of Killeen City Council that they are in fact seizing all of the marijuana. They are not letting anyone go with marijuana. So that's kind of out the window. Let's see what else you're alleging. Worse yet, the officer could be punished by the ordinance to the point of termination from the police force for knowingly following Article 2. I don't know where you're getting that from, because that was taken out of the ordinance, that provision, that was approved by City Council, and using the odor of marijuana was taken out of the ordinance. So you might need to do your homework. Obviously, you spent weeks and weeks, months on this, and you got it wrong because that's not in there. So let's go through and see what else we have in here. Another ordinance inconsistent with state law is the CCP Article 2.13, which states the officer shall execute all lawful processes issued to the officer by a magistrate or court. Warrants extend to every part of the state. Okay, so what they're saying is that City of Killeen cannot execute a warrant for marijuana. That's their read on it. I am not aware of any time that an arrest warrant has been issued and Killeen Police Department has not served it. If you can show any cases, then you need to prove that. But I'm not familiar with any dilemma, any incidents that this is making reference to. The Killeen ordinance also usurps power reserved solely for the legislature. The Texas Constitution says that no power of a superseding law in this state shall be exercised except by the legislature. While the defendant was careful not to reclassify misdemeanor amounts of marijuana as legal, it nevertheless barred enforcement from state law with regards to possession. Plaintiff maintains that if no one takes away the possibility of arrest on the criminal charge, one has effectively suspended the criminal law. Recall that no citation shall be issued either. There shall be no penalty whatsoever. A normal use of the word suspend would include to set aside or make temporarily inoperative. So finally, we'll get into what they're calling the harm analysis. And part 2 of that, 6.02, plaintiffs can think of no greater need for uniformity in the definition and application of criminal law. The Killeen ordinance thwarts the legitimate goals of the Texas Penal Code and risks the creation of a patchwork code that would vary from city to city and county to county. Prosecutors would fail in their duties to seek justice because subservient political subdivisions could effectively opt out of their sworn duty to uphold the laws of this state by refusing to arrest or serve warrants on an offense of their choosing, such as in the Killeen ordinance. Bell County is harmed by this lack of uniformity in the application of marijuana laws. When other states have legalized generally possession of marijuana, they have restricted the use of the drug to a person over 21 years of age. Killeen makes no distinction in this ordinance. Certainly, there are no more immediate consequences for a 17-year-old being caught smoking a cigarette than a joint. Parents in Bell County must face the disturbing prospect that their child can go to Killeen secure in the knowledge that the worst that can happen is a Killeen Police Department officer may confiscate their marijuana. Bell County commissioners and the Bell County attorney are at a loss to explain how this can be legally caught drinking a beer, ticket, and possible suspension of a driver's license caught smoking pot? Nothing. Killeen makes no provision for another agency to take over its misdemeanor marijuana warrants. The county attorney does not have enough staff to complete what should be the Killeen's job in the first place. The city's position regarding prosecution, the county attorney is eager to pursue, is along the lines of, we save the information regarding the seizure if you want to come and get it. Prayer. Finally, plaintiffs request the defendant, City of Killeen, be cited to answer and appear herein, and after notice, show cause why declaratory relief should not be granted, declaring City of Killeen Ordinance Chapter 22, Article 5 invalid, unconstitutional, and void as contrary to state statute. Plaintiff requests this honorable court declare the ordinance invalid, void, and unconstitutional. Then they ask for temporary injunction. Plaintiff requests permanent injunction for the same. And that's it. Respectfully submitted, Bell County Attorney Jim Nichols, Bell County District Attorney Henry Garza. So that is a run through of the ordinance, the lawsuit. So, to my understanding, I attended the NAACP banquet last night. The mayor was there for the City of Killeen, and I asked her, I was like, have you been served yet on the Proposition A lawsuit? She said no. So, as of last night, she had not been served yet. So this is the wheels of justice starting to turn, and we'll see where things land. But Proposition A is on the ballot in the May 6th municipal elections in Harker Heights. There's candidates that support Proposition A, and there's candidates that don't. I'm going to be supporting the candidates that do support Proposition A in its entirety, and we can go from there. The real quick, we'll talk about the legislature probably on the next episode. Majority of this was Proposition A. I do want to talk about the NAACP banquet. A lot of people there from Killeen, Harker Heights, Coppers Cove. They awarded scholarships to students. It was a great event, but to me, what interested me the most was observing our state representative, Brad Buckley, that was there. The guest speaker was the former Killeen NAACP president, and I believe he's up in the Fort Worth area now, and he gave a fiery speech of why it's important to vote. Speaking about regulating guns, gun violence, the idea of the legislature is trying to remove DEI and remove history from being taught, American history from being taught. And it was just interesting seeing his stone face when all of these progressive ideas were being brought to, and people clapping and supporting that. And hey, he was a trooper, because I know he probably don't believe in any of that stuff, but he sat there. But it just made me think that he does not represent our city, our community, and we really need to find someone that does, that'll support what we support, that will stand and fight for us in the legislature, not just come to meetings and banquets and sit there and participate in things, but not support us when it really matters, because that's what he does. The other thing that I want to talk about real quick is the chief of police, Chief Kimball, announced his retirement. The city is looking for a new police chief. We had 5 candidates that we had a meet and greet yesterday with. All of them seem great, knowledgeable, and to me, I think the 2 standouts, I forgot their names, I didn't write it down. The 2 standouts, there was one from Austin, right down the road, and I believe he's like an assistant chief for Austin Police Department. And the other one was from Houston. He's the chief of police for Houston ISD. And I think everyone really gravitated towards him, it seemed like, because he was ex-military. He was stationed at Fort Hood. He lived in the community before. So he's very aware of our history here. So I think a lot of people appreciated that aspect of his career. So I'm assuming that they'll be making a decision pretty soon, and I'm anxious to work with whoever the city chooses, and we can move forward with protecting our city and growing and making it safer for all the residents. And let's see, I guess municipal elections are right around the corner. Early voting, I believe, begins on, let me pull it up, on the 24th, April 24th. Early voting starts. I always like to vote early on the first day that I can. So I believe I'm prepared to cast my vote in District 1. I live in District 1. I'm met both candidates, and I'm confident who I'm going to vote for. The Coalition of Black Democrats, they're hosting a meet and greet today at 1:30. I will be going to that. A lot of the local candidates will be there, so maybe I could get them, just say a hi or something like that and include it in here, or get them for a future show so you could be informed as well. So, I spent a lot of time on the Prop A lawsuit. It's important for our community. It's important for the state of Texas on local control. And, the Attorney General could have brought this lawsuit a long time ago. City of Austin passed this ordinance, this exact same ordinance, probably 2 years ago, and they didn't do anything. So now this has proliferated throughout the state, and it's on the ballot in Harker Heights again. It'll be on the ballot in San Antonio as well. Theirs is definitely more comprehensive because it goes to no-knock warrants. It goes to a bunch of other things. They're calling it a criminal justice charter. And so just to reform a lot of criminal justice stuff down there. It has statewide implications, this lawsuit. And in the legislature, I know that they are expanding, they have House bills that have passed to expand medical use. And I'm sure there's going to be some type of decriminalization or lowering of offenses at the state level. Stay tuned. Thank you for listening, and we are at it here.